also quite different, which means that Pinochet can only take us so far. And if anything, our case is even more straightforward on a submission to jurisdiction than Pinochet. We are concerned with the consent of a state for itself, not the consent of a state by reference to an individual potentially acting on its behalf. In ICSID, we have consent within a scheme for the exercise of jurisdiction to recognise and enforce awards to which a state would be a party in every case. Unlike Pinochet, we are not concerned with the immunities of human agents who have what this court called in Reyes and Al-Malki a corporeal vulnerability. And for your note, that's at Authorities, page 107. Instead, we have an incorporeal state agreeing to engage in the global marketplace. We are dealing with civil, not criminal proceedings. And as I'll go on to show, Article 54.1 of ICSID is a stronger obligation of result to exercise jurisdiction compared to Articles 5 and 7 of the Torture Convention. But having said that, the ratio of Pinochet, properly understood, supports the respondent's case. I'll start by identifying the ratio. In short, it is understood as it was set out in the Queen and Lama. And then I will trace through the reasoning of the Court of Appeal in this case on express submissions to jurisdiction. The respondents agree with the conclusion, of course, that the wording of Article 54 satisfies Section 2 of the State Immunity Act. But we say there's even stronger support in Pinochet for the Court of Appeal's correct conclusion. So, very briefly on the ratio of Pinochet number 3. A majority of 6-1 of the law lords held that Senator Pinochet did not enjoy immunity ratione materiae from extradition for offences of torture. And as stated by the Court of Appeal in Lama, to which you've already been taken, a majority of 4 law lords found that the parties to the Torture Convention decided that immunity ratione materiae should not be available because it would be incompatible with the Convention and defeat its purpose. That majority was composed of Lord Brown-Wilkinson, who was not mentioned in the Court of Appeal below, Lord Saville, Lord Millett, and Lord Phillips, who was also not mentioned in the Court of Appeal on Pinochet. He was on NML. So I'm going to take you to their reasoning in the context of the Court of Appeal's judgment. So if you could please turn to our core bundle at tab 8, 265. This is the Court of Appeal judgment. No, it's the Court of Appeal in this case. And we're starting at paragraph 84.
Page 26.
It's page 265 of ISL's core bundle.
Oh.
Well, 265.
And my lords and my lady, to flag, I will be switching between the Court of Appeal judgment and Pinochet, if you have both to hand.
Right.
So what, paragraph 84?
Starting at paragraph 84, yes, my lord. It's at page 196 of the key documents, my lord, if that's of assistance.
Yes.
Thank you, my lord. So, starting with the subheading to this section, does Article 4 contain an express and sufficiently clear submission to the jurisdiction? The sufficiently clear qualifier is not part of the test for a prior written agreement under Section 2, and in the end the Court of Appeal agreed it was superfluous when they responded to and rejected Mrs. Justice Dias's point that the waiver wasn't sufficiently particularised. In paragraph 84, Lord Justice Phillips recalls that Spain and Zimbabwe rely on Lord Gough's analysis that waiver must be express and not an implied agreement. As has already been observed, Lord Gough was the dissenting judgment and also not in the majority on the ratio point. Mr. Baston explained yesterday that Lord Gough was not dissenting about the existence of a waiver. That's at transcript page 16, lines 7 to 11. But Lord Gough was in fact dissenting by defining express waiver as requiring the actual words immunity or waiver to appear in the text. And that view was not shared by the law lords in the majority. If we could turn to...
Sorry, I need to just think about that for a moment.
Yes.
He was dissenting because the words
immunity
and waiver were not used.
Yes.
So does this go back to the debate we had at the start of today about the meaning of what express consent means in this context?
In one way it does, my lord, but it's also the point that Spain and Zimbabwe are relying on Lord Gough, who was not in the majority on the outcome of the case and was not on the majority of the ratio on what is understood by submission to the jurisdiction.
Yes, I understood you to say that he was not dissenting in relation to whether there'd been a
He
waiver.
was dissenting on both points. I said Mr. Baston yesterday at page 16, lines 7 to 11, said that he was in the majority on this point, which is incorrect. And let me take you to that. So if you're in the Pinochet judgment, which is at tab 58, page 796 of the main authorities bundle, this is Lord Gough's opinion, and it's at paragraph, or it's at page 213 at margin note D. And you can see Lord Gough is explaining that no mention is made of state immunity in the convention, and in his view, he would have expected it to be a separate article or a separate paragraph. On the same page, down the bottom of the page near margin note H.
And he's referring, yes, there to the convention.
Yes, and that we're on the same page, but at the bottom of the page near H, he says, it's actually the final line of the page, there is no express term of the convention.
Sorry, that's page...
It's the same page.
Letter H on the same page?
And it's at margin note H, where he is explaining that the exclusion of immunity is said to result from the Torture Convention, but there's no express term of the convention to that effect. So he's looking for these terms or a separate paragraph dealing with immunity. Interestingly, Lord Gough, on the previous page, which is 795 of the authorities, internal page 212, from margin note C to F, actually did quote the articles of the Torture Convention, Articles 1 to 5 and 7, but he does not analyse the terms. His analysis proceeds on the assumption that that something is missing, namely a specific reference to immunity or waiver.
The whole notion that you need some express form of consent is pretty hard to reconcile with the principle you can waive immunity by taking a step in the proceedings, for example. Exactly,
my lord. Yes. Exactly, which is also in section 2. Another way that a state can submit to the jurisdiction.
Shows you can do something which is simply inconsistent with an intention to preserve immunity.
Exactly. It's not even a state instituting proceedings, which is a very obvious example, but it's a state taking a step in the proceedings without invoking immunity at the same time. That would satisfy submission under section 2. If we could then turn to page 798 of the authorities, we are still in Lord Gough's opinion. This is internal page 215. I won't read it out, but I just note here that Lord Gough cites several authorities to support his view, but none of these require the specific words to be used. All they say is that you can have express consent or submission through a treaty or a prior written agreement. So that is Oppenheim's international law, Article 7 of the ILC draft articles, and the commentary to those articles.
If we look at Oppenheim,
Oppenheim is a...
yeah, the quotation between B and C.
Yes. Well, Oppenheim even accepts that it may waive immunity in the way that Lord Leggett just observed, by implication.
Certainly.
So we see this is an internal inconsistency in Lord Gough's reasoning, that he is demanding specific words, a separate paragraph, specific mention of immunity, and yet the sources that he relies on for that position don't support such a strict test. The next point is at page 805 of the authorities, and this is still Lord Gough.
Page?
805.
Thank you.
And it's at margin note C. And this is where Lord Gough is contrasting the Torture Convention, which in his view does not include a waiver of immunity, with other conventions. And he notes earlier conventions made provision for an international tribunal. In the case of such conventions, no question of param param non habet imperium arose, but heads of state were expressly mentioned, so ensuring they were subject to the jurisdiction. He doesn't name the convention, but when we look at the arguments made in the Pinochet proceedings, it was the Genocide Convention that he had in mind. And just for your note, that was raised in argument at page 748 and at margin note G. And it is true that the Genocide Convention provides for an international penal tribunal in Article 6. According to Lord Gough's reasoning here, that kind of convention providing for an international tribunal doesn't raise any problem of immunity. Well, Article 6 of the Genocide Convention mentioned an international penal tribunal yet to be established. That's in 1948. It wasn't actually established and operating until 2002. And yet for Lord Gough, that provision was enough to remove immunity. We can compare that with the ICSID Convention, which in and of itself establishes a system of tribunals that national courts will recognize and enforce the awards of. So even on Lord Gough's reasoning, when you have a convention making provision for an international tribunal, then there's no question of param param. Turning back to the Court of Appeal judgment and to the paragraph 85. That paragraph is where the Court of Appeal quotes Lord S.A.R.L, finding that the express and unequivocal terms of the Torture Convention fulfill any requirement for waiver. But Lord S.A.R.L made an even more pertinent point for the ICSID context in Pinochet. So turning back again to Pinochet, and this time to page 849 of the authorities. And this is at margin note C. So we're in Lord S.A.R.L's opinion. He notes that the Torture Convention set up a scheme under which each state becoming a party was obliged either to extradite alleged torturers found within its jurisdiction or refer the cases to its appropriate authorities for the purposes of prosecution. And he notes there's an agreement that each state party will establish and have this jurisdiction over alleged torturers from other states' parties. This reasoning, as I said, is even more pertinent for the ICSID Convention, also setting up a scheme in which parties have agreed to cooperate and enforce. On the same page, at margin note H, starting with the word "so far," is another key point from Lord S.A.R.L, where he says that he cannot see how, so far as torture is concerned, the immunity can exist consistently with the terms of the Convention, because each state party has agreed that the other states' parties can exercise jurisdiction over the alleged official torturers found within their territories. And he finds that the simultaneous claim of an immunity cannot make sense. Just to pause on the reasoning of Lord S.A.R.L, which was shared by the other law lords in the majority of 4. In the ICSID Convention, states have agreed to an even stronger exercise of
jurisdiction. The reasoning was shared. Lord S.A.R.L went so far as to say there was waiver. I don't think any of the other 3 went that far, did they?
So he said that the availability of immunity would be incompatible with the treaty and defeat its purpose. And so it doesn't have to use the words of waiver, but he found the inconsistency and the exercise of jurisdiction and the immunity.
Certainly there were 4. On my present reading, there were 4 who found the inconsistency.
Yes.
Lord S.A.R.L went further than the others in
Yes.
saying that there was waiver.
Yes. And on the other side, we had Lords Hope, Hutton and Gough, who disagreed, but for very different reasons.
Yes.
Yes. So turning to the comparison of the exercise of...
If you're going to move from 267,
Yes.
there's a passage at 267 F to G. Just before the passage.
Yes. This is on page 850?
850 of the bundle.
Yes.
It struck me that the passage at F to G employed reasoning very similar to that on behalf of the respondent in
Yes.
this appeal.
Yes. Yes, my lord. Indeed, I would say that all of the law lords in the majority favour the respondent's case, and of those, Lord S.A.R.L is probably the closest in terms of how he expressed that reasoning.
Thank you.
Thank you. If we could turn to authorities 2764, which is the Torture Convention. And I bring your lordships and my ladyship to these provisions, just to build on a point that my learned friend Mr. Harris made, which is we're dealing with an even stronger exercise of jurisdiction under the ICSID Convention compared to the Torture Convention. So in Article 5 on page 2764, states have agreed to take measures as may be necessary to establish jurisdiction over offences in cases with various links to the state, but also on the basis of universal jurisdiction when an alleged offender is present in the territory. And over the page at Article 7.1, the state agrees to extradite or submit the case to its competent authorities for the purpose of prosecution. So the key point here is that Article 7, very understandably, is formulated to leave it to national authorities to decide whether or not to initiate proceedings, respecting the independence of each state's judicial systems. It gives them a discretion as to how they extend that jurisdiction. We can contrast this with Articles 53 and 54 of the ICSID Convention, where the obligation to exercise jurisdiction is much stronger. It is to recognise an award as binding and to enforce, not to submit to authorities to consider enforcing, but to enforce the pecuniary obligations imposed by that award within its territories. And then, as was discussed with Mr. Green before lunch, the importance of the words final judgment in making that a very strong obligation. So, if on the basis of this extension of jurisdiction we have the submission to jurisdiction and the removal of immunity, then even more so on Articles 53 and 54 of the ICSID Convention. Turning back to the Court of Appeal judgment at paragraph 86. This is where the Court of Appeal relies on Lord Millett, that immunity may be asserted or waived by the state, but where it is waived by treaty, the waiver must be express. And again, there is even more relevant analysis from Lord Millett in the Pinochet judgment, and that will be at page 860 of the main authorities bundle. So that's near the bottom of the page, 860, from G going over to A on the following page. I'll let the court read that paragraph. So an interesting point here in Lord Millett's analysis is that he says the evidence shows that the other states were to be placed under an obligation to take action precisely because the offending state could not be relied upon to do so. We've seen that Article 54 places contracting states under an obligation as well, even if, as the survey of the Travaux have shown, there was perhaps greater trust in states acting in good faith at the time of its conclusion. The Court of Appeal does not refer to the reasoning of Lord Brown-Wilkinson or Lord Phillips in Pinochet at all. But if I may, I'll bring you to some very pertinent paragraphs in their opinions. So first, Lord Brown-Wilkinson at page 787. And this is between margin notes F and G. The point being made here is that he found it significant that the Torture Convention, and he also mentions the Hostages Convention, are establishing a new type of jurisdiction where domestic courts are being required to take jurisdiction. That is a good parallel with the ICSID Convention. And over the page, so this is at page 788 of the main authorities, and it's from margin notes F to G. I won't read it out, but Lord Brown-Wilkinson emphasises the importance of the regime being established. In the case of the Torture Convention, it was a regime under which there's no safe haven for torturers. And under the ICSID Convention, it is a regime for mitigating sovereign risk and promoting investment protection. The next opinion is Lord Phillips, which is at page 873. Starting at margin note E. And I'll just give you a moment to read that. It's from E to G. So Lord Phillips is speaking of two possible routes here. One, that there is no immunity for torture per se, and he was attracted to that argument, as was Lord Hutton, who was not in the majority on this point. But also a second possibility of express agreement, and he agreed that either route was fatal to immunity, and it was the second route that obtained the majority in that case. So we have 4 law lords in Pinochet clearly holding that consenting to the exercise of jurisdiction, consenting to a scheme requiring the exercise of that jurisdiction, with provision for how that is to be exercised in practice, satisfied the tests for submission.
Does it matter to the analysis whether it was a waiver or whether it was an agreement or whether it was a conclusion that the fact that the terms of the treaty meant there was no immunity at waive?
It doesn't matter, my
Doesn't
lord.
matter.
It doesn't matter, my lord. The overarching concept here is consent, the consent of the state and the states in their agreement, and waiver or submission or incidents of that consent. But the removal of immunity, if it was there to be removed, is through the consent. Now, there are scenarios which are not pertinent to our case where you can have a waiver that's not a submission or a submission that's not a waiver, but that is not the case here. And just to give you an example, filing a defence on the merits in a case without raising immunity would be a submission, but it's not an express waiver under the scheme of the State Immunity Act. But the actual characterisation is not definitive. My lords, my lady, I now turn back to the Court of Appeal judgment and to paragraphs 88 to 90. And this is the High Court of Australia. Mr. Green will come back to this judgment. I just want to highlight 3 short points from it. So this is, in paragraph 89, there's extracts. The Court of Appeal has extracted the paragraphs from the High Court of Australia. So if we're looking at paragraph 26, so this is within paragraph 89 of the Court of Appeal, but it's paragraph 26 of the High Court of Australia. And the first point there is that the High Court of Australia speaks of an unwilling state. This is about just over halfway down the paragraph 26. It says, there is no room to recognise an implication of consent of an unwilling state which has not expressed its consent in a clear and recognisable manner. That's entirely true, and what's very important in the context of ICSID is that all of these states are willing. And back to the point Mr. Green was making before lunch, they were exercising their sovereign authority to make this agreement. So it's the opposite scenario where we have willing states consenting to the exercise of jurisdiction. Just underneath that, there's a quote from Chief Justice Rehnquist of the United States Supreme Court in Amarada Hess. This was also quoted by Lord Gough, and that's the context in which the High Court of Australia is mentioning it. And it's the statement by Chief Justice Rehnquist that a foreign state will not waive its immunity merely by signing an international agreement that contains no mention of waiver of immunity to suit in US courts or even the availability of a cause of action in the US. The Amarada Hess is a very good example of a case where you would not have submission. That is a case where the treaties in question were the Geneva Convention on the High Seas and the Pan-American Maritime Neutrality Convention. Argentina was party to those treaties, but that did not create any rights of action or a scheme for private entities to recover compensation against Argentina. Those treaties had very broad objects and purpose with defining maritime zones and state activity on those zones. So the plaintiffs in that case that tried to use those treaties to claim that there was a submission or a waiver did not succeed. And
there were two treaties. One was the Geneva Convention on the High Seas. The other one was
the Pan-American Maritime Neutrality Convention. And they were invoked by the plaintiffs and rejected by the US Supreme Court as providing for submission. So the statement by Chief Justice Rehnquist is entirely correct, because in the context of those treaties, the agreement did not constitute a submission to jurisdiction for the facts of that case. And the last point from the High Court of Australia for me to mention is at the bottom of that page and over the page in internal paragraph 27, where there's already been some discussion in these proceedings about the use of the word inference, but it is clear that the court was using the word in a linguistic sense, but functionally the High Court of Australia was undertaking interpretation of the actual terms. And Mr. Green will be developing that point. And then, and this is the final section of the Court of Appeal judgment that I will mention, just to flag that at paragraph 91 of the Court of Appeal judgment, there is a suggestion from Spain and Zimbabwe's argument that the High Court had reached its conclusion under pressure, and the Court of Appeal rightly says this is without merit and without a necessary factual foundation. And at the following paragraph, paragraph 92, the Court of Appeal again was right when it said that what the High Court of Australia considered to be expressed did not require the actual use of the terms waive or immunity, but simply the construction of the words used. So, my lords, my lady, the key takeaway from the ratio of Pinochet for the purposes of this case is that where you have consent to the exercise of jurisdiction under a treaty that is incompatible with jurisdictional immunity, that immunity is removed or didn't exist in the first place. This is not a question of effet utile in the way that Zimbabwe put it. It is not a test of whether something is completely incompatible or devoid of effect. It is a matter of interpretation as set out by Mr. Harris earlier. And if anything, a test of effectiveness with a view to the object and purpose of the convention is in favour of the respondent's case. We have in the ICSID Convention states themselves agreeing to the exercise of jurisdiction over other contracting states as part of a scheme to recognise and enforce awards. And in that way, the analysis of immunity in Pinochet is helpful. Now, there are cases where it involves criminal proceedings or individuals where a further inquiry will have to be undertaken by the court, whether the intention was to exercise jurisdictions over all individuals, whether those individuals are state officials, whether we're concerned with immunity ratione personae or ratione materiae, or with diplomats and special regimes, whether these are criminal or civil proceedings, as the court confronted in Jones. But these questions for further inquiry are not present in our case. We don't have these further complications. This court can decide that Section 2 of the State Immunity Act is satisfied by the provisions in ICSID, and there's no need to go further into the inquiry beyond that. Unless I can assist Further, my lord and my lady, Mr. Green.
Thank you, Professor Webb. We're very grateful.
Thank you.
Slight manoeuvre required. Get rid of some of those things. Learned Friends Economy and Erudition have left me not quite ready with my bundles. Catch up. My lords, my lady, can I pick up the point of FAUT, which was a submission made by my learned friend, Mr. Moulan, and just in relation to that, we say that not only was the application of the concept of FAUT incorrect in Pinochet for the reasons that his submission in relation to that incorrect, but also it has rather upset the apple cart of what FAUT actually means. So it's completely true that one incident of the doctrine of FAUT is that if you deprive a provision of any meaning at all, that construction is wrong. So it's certainly true, as my Lord Lloyd Jones said yesterday, if you show that you've deprived the provision of any meaning, that can be wrong, but that's not the only way that the matter can be decided. And the correct position is that the doctrine of FAUT in international law actually finds expression within the good faith principle of effectiveness in Article 31.1 of the Vienna Convention. And it's merely an extreme incident of the doctrine that when you show no purpose is served whatsoever, it definitely cannot be the right construction. And that's the sort of cousin of our domestic concept of Parliament does not legislate in vain. But it's completely wrong to characterise the doctrine of FAUT as confined to that, or to say that that is the test that the court should approach, should adopt in construing the provisions of the Convention. And this is helpfully pointed out by Mr. Justice Bryan in GPF and Poland at the Joint Authorities bundle at page 397.
Can I just start, why do we need to debate in terms of FAUT? I mean, I would have thought that your argument is, look at Article 31.1 of the Vienna Convention. The concepts there are good faith and other things, including object and purpose.
Oh, my lord, I'm only making the submission out of an abundance of caution, because the court was invited by my learned friend Mr. Moulan to adopt that process in his submissions. The short point is, I don't need to go into it in detail, but the short point is in GPF and Poland, if the court has page 397 of the bundle, the judgment, actually, this passage of the judgment is divided into sections, and G2, that letter little g on that page, is FAUT, the principle of effectiveness, with which EU lawyers will be very familiar. And it's actually a principle of effective interpretation to give purpose to the provisions in accordance with their object and purpose as part of the exercise of a good faith interpretation of the treaty. So there's no separate... Your Lordship's completely right, Lord Sales is completely right. I don't need to make the submission, but I just don't want any suggestion that there's any separate doctrine floating around that undermines the approach that learned friend Mr. Harris carefully went through correctly in the approach to construing the convention in that way. The sort of side note to that is that members of the court will be very familiar with how powerful the principle of effectiveness has become as a matter of EU law, probably even more powerful as an operative, active principle, rather than a negative incident of the principle that we were considering a moment ago. Can I just briefly deal with the Hansard point in relation to the 1978 Act? So we respectfully say that our primary submission is it's not relevant in 1978 to any ambiguity in the 1966 Act.
I mean,
It doesn't.
I didn't think we were talking about ambiguity in the 1966.
I'm taking it in stages, my Lord.
All right.
Just clear the undergrowth. As there's no actual ambiguity in Section 2 either, nor is there ambiguity in Section 9, we say. And in any event, it would fail the second requirement in Pepper and Hart for the requisite clarity for the material to be admissible. And this is, first of all, because what was being considered was the enforceability of all our foreign arbitration awards. Secondly, because the words used by the Solicitor General were to ensure that they would all be enforceable, having just mentioned the ICSID obligations. And I completely accept that he expressly mentioned the ICSID obligations. They were not the obligations, and those flowing from the 1966 Act, that he was promoting. So for the purposes of Pepper and Hart, he is not the person who is the expert, as it were, making a binding statement in Parliament about the effect of the 1966 Act. And in addition...
He's not the promoter.
He's not the promoter of the 1966 Act at all. And in addition to that, there is an obvious reason why, where you've got, and this is the temporal point again, where you've got something, so the 66 Act comes in, and as my Lord Lloyd Jones put to me before lunch, might be said against us that submission wasn't permitted in 1966. That was the common law, as understood. That is why an Act of Parliament changing the common law was necessary. And there can be no doubt that the 1966 Act did change the common law. And it would be quite wrong, having discussed FA-UTIL, to say that Parliament legislated in vain in the 1966 Act to require the courts to do something that they could not do. Because the 78 Act didn't come in for another 12 years. And so going back to the Hansard point, which I've taken a slight detour, I appreciate, the words ensure that foreign foreign arbitration awards can be enforced, and having just mentioned the ICSID awards, there is every reason in 1978 to make sure there is no lex specialis argument available on Section 9 that might be argued, oh, well, no, you can see the ICSID Convention concerns arbitration awards, and they're separately dealt with in Section 9, so they can't fall under Section 2. So there's a perfectly reasonable basis for the Solicitor General to say that doing this will ensure that all arbitral awards can be enforced. Ensure is an important word. So we say that that context means that the Pepper and Hart material doesn't meet the second criterion of sufficient clarity. My Lords, going back, if I may, just for a moment to the context, the object and purpose of the Convention, and I take my Lord Legate's point that there may be nothing between object and purpose.
Or Briggs, actually.
Yes.
I don't mind.
I'm great. I think it may have been picked up by Lord Legate and run with, so it may be a team effort, if I may say so. But the object and purpose, it is quite important to identify with clarity the underlying mischief, if I can use that term in not a pejorative way, at which the Convention was aimed. Because the acts in respect of which an investor may wish to bring an arbitration claim would be frequently, if not always, sovereign acts on that country's own soil. So that is an important point of context, that it's liability for sovereign acts on that country's own soil, typically, that is being contemplated. And that is quintessentially something for which there would be unlikely to be any jurisdiction. So this is why the Convention was such an innovation, because it was doing two things. Firstly, it was an international law instrument creating private rights for investors, which we're much more familiar with international instruments conferring private rights now than was the case then. That's the first thing. And the second thing was, it was creating for individuals private rights in relation to acts which may well, ex hypothesi, be lawful when there's a sovereign act within the territory of the state whose conduct that was. So there could have been no doubt, and indeed Mr. Brocker says in his commentary, that this was a huge innovation, this Convention. And there was no doubt that that was the case for that very reason. And if you take the example of Spain, in our case, in that example, Spain changed the law about the support payments for green energy. So as a matter of Spanish law, Spain is correct. But under the Energy Charter Treaty, that change of law, sovereign act, that you could not win on in the domestic law of Spain, that is an act which, if it breaches the FET standard, which it did in Article 10 of the underlying treaty, Spain can be liable for, as the court well knows. I'm only spelling it out because that informs what, in a sense, strengthens the seriousness and magnitude, in a sense, of what all the contracting states were agreeing to do. And that's at one end of the analysis. At another, if I can pick up Lord Legate, and I think it was Lord Legate rather than my Lord Briggs, Lord Legate's point about the pecuniary obligations, at the other end of the telescope, the pecuniary obligations was a refinement of what was going to be enforced in the award domestically. And so there is a point on negotiation that is, it's not a matter of applying domestic law concepts, but just as a matter of common sense. When the contracting states have negotiated as part of their agreement a qualification to something in some detail, that it will only be, for example, the pecuniary obligations, that reinforces the fact that they are deliberately consenting to that specific consequence. And that is a feature that emerges compellingly from the travaux if resort is had to them, but in any event from the plain words of the convention where there's the qualification, that qualification. My lords, as to the convention itself, I hope you'll forgive me, but I'm going to give the court a quick guide, if I may, to the relevant observations of Professor Schroyer and his commentary, which was cited with approval in Mikula and is regarded as authoritative by practitioners, is at tab 252, begins at page 3541, and this is the up-to-date third edition, which was 2022. And I won't take the court to it in extenso, but I'll try and identify the key points, which I think are of assistance. At page 3552, there is the exhaustive nature, heading 1, halfway down the page, the exhaustive nature of the Convention's review system. I apologise to my Lord Lloyd Jones and Lord Sales. I think I may have taken the court to this in Mikula, but the exclusive nature of the remedies provided are discussed, with the exclusive remedy rule in Article 26, paragraph 26. Paragraph 27 on the next page, 3553, serving the interests of finality awards and providing a clear advantage over other arbitration mechanisms, which can be, at the end of that paragraph, subject to potentially protracted and costly review procedures by the courts of the arbitration forum, which the Convention was seeking to avoid. If we go over the page, there's a reference to the decision of the ad hoc committee in Mine and Guinea. And if you come down for 7 lines on the right-hand margin of the quote at the top of the page, you can see there's a sentence in that line. It appears from these provisions the Convention excludes any attack on the awards in national courts. And then 29, the submission I made 5 lines down on the right-hand side of that paragraph. Consequently, a party to ICSID proceedings may not initiate actions before a domestic court to seek annulment or another form of review of an ICSID award. A court of a state that's a party to the ICSID Convention would be under obligation to dismiss such an action. And that was, we respectfully submit that's consonant with the submission that Spain's actually in breach of the Convention in making the submission under Article 53, as I said before. And then if we go forward to page 3555, there's a ICJ point at the end of paragraph 35. This means, in particular, a contracting state may not evade its obligation under Article 54 to recognise and enforce an award by arguing its nullity before the ICJ. So that is also precluded. And then 3557 is this is all under Article 53 at the moment, exclusion of another remedy. And over the page, I could probably skip that part. I'll go forward a bit, if I may. I'll take the course, just going a bit faster. I'll just fast forward, if I may, to Article 54, which starts on page 3570. And if we look at page 3573, and you look at paragraph 4 at the top of 3573 and come down to just after the list of page numbers, about 6 lines down on the right margin, you'll see Mr. Brockes argued successfully in favour of limiting or eliminating the grounds for review contained in the New York Convention and the independence from that convention and other international domestic rules is highlighted at the end of that paragraph. And then your lordships will see at page, paragraph 6 on that page, the point on Article 192. And the basic idea of an automatic recognition of ICSID awards was modelled on Article 119 of the Treaty of Rome. And your lordships will see there, and my lady, will see page 425 listed in the list of pages, which was the page that I took the court to, relating to the member states having qualified their sovereign rights.
Does it get any extra force because Professor Schroyer has mentioned it in his commentary of that page? I mean, I'm not quite sure what we're getting from all this.
Well, my lord, all I'm saying is that there's much emphasis placed on the proper interpretation to be put on the travaux by Mr. Moulin. And perhaps all I can say is there are, throughout the passages in Schroyer, the entire piece shows that you cannot challenge judgment or jurisdiction in domestic courts afterwards, and the entire commentary is referenced back to either Mr. Brockes or to pages within the travaux. So my overarching submission, a fair question obviously from my lord, my overarching submission is island hopping in the travaux, as you were invited to, is dangerous. The account by Mr. Brockes, based on the pages of the travaux, and the account given by Professor Schroyer, cross-referenced to the travaux, is a fairer and surer guide to selected highlights taken out of context. So that's really the purpose of the submission, my lord. There are striking points at 3585. ICSID awards must not be made subject to conditions of recognition not provided for in the Convention.
I'm just slightly surprised that you skipped over the end of paragraph 7 on 3574. Because that's where Professor Schroyer seems directly to deal with the reciprocity, mutuality.
My lord, your lordship will see I've got a massive pink asterisk beside it on the page. But your lordship,
you were going to come back to it.
Your lordship's completely right. It says all drafts. I mean, firstly, the key point above the list of pages in the history is a provision on enforcement was seen as necessary to balance the situation in favour of the host state, which we totally accept. But immediately follows, as your lordships pointed out, but all the drafts leading to the convention refers to the recognition and enforcement against the parties in equal terms without distinguishing between investors and host states. And it's clear this was also the intention of the drafters. So that's unequivocal. And
Sorry, I interrupted you.
No,
You're going somewhere.
well, my lord, no. I was trying to slightly accelerate because I don't want to try the court's patience on it, but it is instructive, and you can see. I mentioned earlier this morning that 3579. I mentioned that there was consideration of equating an award to a foreign rather than a domestic judgment. That's referred to by Professor Schroer at the end of paragraph 25 at the top of 3579. In the context, as the court will see, the idea, 3 lines down, the idea to make awards enforceable in third states that were unconnected to the arbitration ran into some opposition. Compromise suggestions were made to treat awards in third states like foreign rather than domestic judgments, or to allow third states to refuse recognition and enforcement on the ground that the award was contrary to local ordre public. Eventually, these suggestions were voted down, and full enforceability of awards in all states parties to the convention was preserved. So, I've been obviously to 3585, which is not making them to conditions. As to enforceability, my Lord Legate, I think, asked me about enforceability. If you look at 3586, para 56 is about recognition, and you'll see the second sentence says, recognition is subject only to the requirements of the Convention and may not be refused for reasons of domestic law. And then 54.3 subjects execution to modalities, that's plain on the words, we say. And then 57, the provision on sovereign immunity from execution in Article 55 does not apply at the state of recognition. Submission to arbitration may be seen as a waiver of immunity in proceedings that have award recognised. Therefore, the effect of the award as res judicata will apply irrespective of any immunity from execution. So that's its that's in relation to res judicata. It's fair for me to observe, because I think my Lord Legate asked for the French version as well of the text. There is a wrinkle about the difference in meaning between enforcement and execution in some civil law countries, which is discussed at 3593. But I can deal with it shortly, certainly in relation to the French text, because if we go back to 3587, so this was in the course of trying to land the final award without being prisoner to any of the domestic law, terms were used such as enforcement, which may mean slightly different things in different jurisdictions. But if you look at the top of 3587, paragraph 61, the Cour d'Appel of Paris upheld an appeal. After quoting Article 54 of the Convention, the court found that this provision lays down a simplified procedure for obtaining an exequatur, and that the function of the court concerned was restricted to ascertaining the authenticity of the awards certified by the Secretary General. So, in terms of application, both there and over the page at 65, on 3588, the decisions of the French courts draw a clear distinction between recognition of an award and its execution. There's no sovereign immunity with respect to recognition of award. Immunity under Section 55 only arises when actual measures are taken. So, although there is a textual difficulty that arises, there's no difficulty in practice. And then pecuniary obligations, to the extent that those negotiations are relevant, is dealt with at 3595 under its own heading. If we go to finality and reviewability at 3598, the court will see there, that's the beginning of that section. And if you go on to the next page at the top, talking about the self-contained scheme of the Convention, a domestic court or authority before which recognition and enforcement is sought is restricted to ascertaining the award's authenticity. It may not re-examine the ICSID tribunal's jurisdiction. It may not re-examine the award on the merits. And there's a little more to that effect. Those are the key provisions which we respectfully say are a rather surer guide to what happened in the travaux, if there is to be resort to the travaux, which on our primary submission is not necessary. Because both in Mr. Brox's account and in Professor Schroyer's, they actually refer to the individual pages of the travaux from which they draw those conclusions. My Lords, just one small point that my learned friend mentioned, that there was an undertaking in his case, by Zimbabwe to pay the award. There was a similar undertaking before the ad hoc committee by Spain, which said that it was going to pay the award, but to seek clearance from the Commission first. So that's the equivalent undertaking that was given in our case, but it remains unpaid. There are several cases presently stayed in the commercial court awaiting this outcome, the outcome of this case. There are also UNSA-TRAL awards which relate to the matters which arise on day 3 and 4. There are a very large number of awards dependent on the outcome of this case. May I just do a very short, I hope fair, reference to the judgment of Mr. Justice Fraser below, because it's quite easy to criticise the first instance judge after the event. And we respectfully say that the Supreme Court in Micula was not concerned with state immunity. And that's perfectly clear. There were two key issues, as my Lords, Lord Jones and Lord Sales are very well aware. First of all, what was the nature of the United Kingdom's convention obligations, particularly as to whether they were multilateral, because that informed the argument on Article 351. And the second issue was the nature and effect of the substantive obligations under the Convention and the 1966 Act, and the extent to which those precluded a delay, only a delay, not a refusal, a delay in relation to registration and enforcement. So, and although the court was not deciding the issue of state immunity at all, it is fair to Mr. Justice Fraser, as he then was, fairly to record that the conclusions reached by the Supreme Court in that case, as to the nature of the obligations under the Convention and the 1966 Act, drive one to the conclusion that there is no scope in reality, I'll come on to what I mean by that, for the domestic court to refuse registration or to set aside a registration order. And with the greatest respect, he was right about that. The authority of Tethian, which the court's been referred to, is pretty striking for two reasons. And if I can take the court to it, Tethian is at, one second, can you pass me my sheet? Momentarily lost my reference sheet. Tethian in the bundle, if someone could give me a reference, Sorry? 2082. If the court can just look at Tethian in 2082. So Tethian was the return date of an injunction, and at 2083, the court will see that TCC had filed an additional application seeking to register the award. And if you go to page 2086, paragraph 16, it says, matters did not start well for TCC. TC's counsel had to concede and wisely did so, that the statutory provision upon which TCC had relied in part in order to obtain the ex parte charging order, that is the Charging Orders Act 2020, was not yet in force. So it was without being pejorative, it was a bit of a car crash from the outset, because they'd obtained this ex parte. And then if we go down to paragraph 27, they refer to State Immunity Act, and that is then considered thereafter. And the reasoning in relation to this, as the court will have seen, is incredibly short at the end, paragraph 50 and 51. And it's essentially in two paragraphs. So without any disrespect to Mr. Justice Wallbank, it is easy for this court to imagine the situation he found himself in on the return date of injunction largely granted on the basis of an act that was wasn't even yet in force. So there's the context, to be fair to Mr. Justice Wallbank. But in addition, you can see there, and from Mr. Bastin's observations, that the relevant textbooks weren't actually before the court, that the matter was far from fully argued, but putting it very mildly indeed. My Lords, one very small point of detail, just in relation to, I'm sorry to be collecting a bag of separate points, but one small point of detail in relation to the Article 192 point in the negotiation of the treaty is that Costa and ENEL case in the ECJ, as it then was decided in July, on the 15th of July 1964. So the full reach and impact of the conferral of competence by member states under the Treaty of Rome would have been very well understood, and there could have been no doubt about it by that stage during the course of the final negotiations in relation to in the travaux préparatoires. Just give me one moment. Just turning finally to the position in relation to the estoppel argument that you're going to hear from my learned friend, Mr. Keneally, tomorrow, from Border Timbers. The ISL respondents' position in relation to that is as follows. On the basis of the submissions that I've already made in relation to the nature of the convention, the closed scheme and so forth, and the clarity of the 1966 Act, the point doesn't even arise. And the point is answered, if I may say so, by the decision of Milady in the Court of Appeal in Sayn-Wittgenstein, where Section 9 asked a question but did not say how it should be answered, and it can be answered by reference to normal English law. And we say as the court will have appreciated already, that because of the 1966 Act, an English statute dealing specifically with such a situation is a good and complete answer to the question. And because there is no provision for any de novo review, and there cannot be any challenge to the tribunal's jurisdiction, its decision in relation to there having been an agreement to arbitrate which vests it with jurisdiction is final. And that is why we put our case as the SIA applies, but the question that the SIA asks in either case is answered by the Convention, the 1966 Act, and the presence of an authenticated award. So we say asked and answered. And if we're wrong about that, then we embrace the estoppel argument, which our primary submission is that it's not necessary, but all of the submissions we have made, saying asked and answered, go to support my learned friend Mr. Keneally's arguments in relation to his estoppel argument. Finally, my lords, my lady, if I may, I'd do my last few minutes, just to turn to the decision of the High Court of Australia, briefly. The High Court of Australia spoke in terms of in a process of inference and interpretation. The short point that my learned friend Professor Webb made is that functionally the High Court of Australia undertook the correct analysis as a matter of international law.
Are you going to be making again now the point she's made, or
No,
about the purpose of this submission?
Well, I'm just going to slightly amplify it, if I may, just to say functionally undertook the correct analysis, but in doing so, the focus on what the states had consented to was the correct focus of the inquiry for the purposes of a convention. So where it's a treaty or convention, the key question was whether or not the states had consented from the words used. And so the only addition I would make to my learned friend's submission is this, that the 2 points remain. First, what does the court see as the meaning of the words in fact used, not words that are missing? So it's the words that are used, not words that are missing. And what is their meaning in context? Always having regard to the aspect of international comity that I referred to before lunch, of a court being vigilant to see that state immunity is not waived or displaced by a sidewind. But there can be no room for that argument in a case such as the present convention, which was negotiated extensively, as the court's already well aware. So there is no place for that. So on that analysis, the semantics used by the High Court of Australia with reference to implication or inference are irrelevant to the analysis. It's a matter of description, and we say that the Court of Appeal was right to rely on the decision of the High Court of Australia as it did. My lords, my lady, those are our overarching submissions. You've got clarity on what the Convention was trying to do to get over all the differences between state immunity and local rules, and then leaving execution to domestic rules of procedure under Article 55. We say that when conceived in that way, which is plainly the right way, the plain words of the Convention are definitive, as is the 1966 Act, and that's with respect an end of the analysis. I don't know if there are any matters upon which I can assist any members of the court.
Don't think so. Thank you, Mr. Chairman.
I'm most grateful.
Thank you. Mr. Baston.
My Lords, my Lady, only a handful of points in reply. I will begin with the points on arrest warrant. My learned friend, Mr. Harris, suggested that this case and paragraph 59 is not about a waiver of jurisdictional immunity and rather is limited to the question of whether a treaty creates an exception to a customary international law rule. My learned friend suggested that the court ought to read paragraphs 56 to 61, but then did not take the court to them. I would like to do so in order to make good the point that this decision is a clear articulation of a general principle that one does not collapse jurisdiction and immunity into a single unified concept, as I suggest my learned friends have been doing over the course of today and yesterday. The relevant page in the bundle is in the supplementary bundle, first supplementary bundle, and we pick it up at page 119. At the top of 119 is paragraph 56. This contains Belgium's argument on the specific matter at issue before the court, namely that immunities accorded to incumbent foreign ministers can in no case protect them where they are suspected of having committed war crimes or crimes against humanity. Scrolling down towards the bottom of the page, after the court sets out how Belgium developed its argument, at paragraph 57, the court sets out how the Democratic Republic of the Congo responded to that specific point. Again, the point being that there can be no immunity for certain types of crimes in international law. Over the page, we come to paragraph 58, where the court deals with that specific argument. It says that it has carefully examined state practice, and then at the bottom of the second subparagraph in 58, so about 2/3 of the way down the page, the court reaches its finding on the specific argument recorded at paragraph 56 that we just saw.
Sorry, you're reading now from 58, where?
So there are 3 subparagraphs in 58, my Lord.
Yes.
The bottom of the second subparagraph, the last sentence is, it finds that these rules likewise do not enable it to conclude that any such exception exists in customary international law in regard to national courts. And then it goes on to make the same point regarding decisions of the Nuremberg and Tokyo International Military Tribunals. Paragraph 58, therefore, is where the court deals with the specific proposition advanced by Belgium before the court. Paragraph 59, however, is an elaboration by the court. And it's an elaboration that establishes a general principle relating to the nature of jurisdictional immunities. I won't read the paragraph again. I know the court has seen it a number of times. But one can see from the structure of the paragraph that the court there is saying it should further be noted. So in addition to and separate from the resolution of the specific argument advanced by Belgium in the case. And that first sentence there talks about the way in which the rules governing the jurisdiction of national courts, the jurisdiction point, must be carefully distinguished from those governing jurisdictional immunities. Not the rule that Belgium had advanced or proposed, not a rule of criminal jurisdiction, not a subset of the rules, plural and in toto, governing jurisdictional immunities. The reason I labour this point, my lords, my lady, is because the existence of this general principle is not made only once by the International Court of Justice in paragraph 59. This is a preoccupation of the court to ensure that national courts understand that it's a matter of international law, their jurisdiction and the existence of it is a separate concept to the existence of a jurisdictional immunity.
Where does that take you?
I will continue, my Lord. It takes me to the point that the way in which my learned friends for the respondents suggest that Article 54 ought to be read as collapsing the concepts of jurisdiction and waiver of immunity into that one sentence in Article 54.1. We should be clear, it is only that sentence that is an issue before the court. The statements of facts and issues by both parties, by all four parties, I should say, have made it clear that that is the only basis where the waiver is said to exist in that one sentence.
Well, that sentence takes you to a final equivalent to a final judgment of the local court, and both jurisdiction and immunity, if it's different, have gone by when you get there.
With respect, my Lord, that is the very collapse that paragraph 59 of arrest warrant, and another case that I'll come to, says that this court ought not to engage in. If one is talking about a final judgment of a national court, that necessarily goes to the jurisdiction, that necessarily goes to the merits of the question. Jurisdictional immunities are self-standing and anterior. They are also of the utmost consequence, as Lord Justice Collins, as he then was in ETI, explained. So that articulation of what that sentence says, my Lord, and the reference to a final judgment of the court is exactly the point, and it favours the interpretation that Spain and Zimbabwe have been advancing. It goes to jurisdiction. If, as my learned friends urge on the court, the guts of their submission is that 54.1 gives us jurisdiction, they are wrong. It fails on that basis alone. And it fails because they are saying jurisdiction has been extended pursuant to Article 54.1, and therefore there ought to be no barrier to that jurisdiction being exercised. Wrong, and plainly wrong as a matter of international law. As paragraph 59 of arrest warrant makes entirely clear, but I'll come to another authority, those two concepts must be carefully distinguished from one another. And jurisdictional immunities come first, and where the immunity exists are a complete answer. Let me take you to the additional authority, if I may, my lords, my lady, because that was by the court, the International Court of Justice, in 2012 in the jurisdictional immunities judgment, which this court has had occasion to consider before, for example, in general dynamics. It's at page 1135.
We considered it last week, Mr. Baxter.
Oh, indeed, in Shahabi, you're quite right. Numerous people in this room have been looking at it for a number of reasons. And I should be clear, this is the general dynamics decision of this court, not the later decision of the Court of Appeal that I'm referring to. Yes. I know your logic is.
Yes. So we're going to jurisdictional immunities, page?
That's in the main authorities bundle, not the supplementary, at page 1135. The authority begins at 1095, but the relevant paragraph is paragraph 82. Given the familiarity of the court, I can no doubt take it relatively...
Well, we weren't all sitting.
It's a large load before the end of the year, I know. At 82, it says, at the outset, so immediately plugging into the anterior and separate conception of jurisdictional immunities, the court must observe that the proposition that the availability of immunity will be to some extent dependent upon the gravity of the unlawful act presents a logical problem. The court may well recall that in this case, the question was whether jus cogens crimes could be justiciable before the courts of Italy, or whether jurisdictional immunity operated as a procedural bar to prevent that. And the court was clear, unequivocal, and strong in saying, you cannot bypass immunity. If it is the case that the court is reiterating this principle again, when we are talking about jus cogens crimes like war crimes and crimes against humanity, and saying those go to the merits and they must be kept out by this procedural bar, in my respectful submission, the concept of recognition and enforcement of an ICSID award is no more compelling a reason to bypass jurisdictional immunities that are expressed in these anterior and absolute terms. I continue in the second sentence. Immunity from jurisdiction is an immunity not merely from being subjected to an adverse judgment, but from being subjected to the trial process. It is therefore necessarily preliminary in nature. Consequently, a national court is required to determine whether or not a foreign state is entitled to immunity as a matter of international law before it can continue. Now, that is not squarely on point for the determination of this court as arrest warrant paragraph 59 is. But the reason I come to it is because it is again a clear statement of the general principle that jurisdictional immunities must come first, they are an absolute procedural bar, and they are certainly not to be collapsed and commingled into questions of whether a particular treaty has extended the jurisdiction of national courts. To do so goes beyond being incorrect as a matter of law. It goes beyond being incorrect as a matter of appreciation. Rather, the International Court of Justice puts it in blunt terms. That is a logical flaw. There is, in my respectful submission, no logic in the submission that the respondents urge upon the court. And we've seen
the fact that it's necessarily preliminary go against you, because it shows it's necessarily being waived if you're agreeing to treat the award as a final judgment of the court. You must necessarily have decided the question of immunity that it doesn't apply in order to get there. Sorry.
No, sorry, my lord.
I was just making... you got the point anyway. Yeah.
I'm grateful, my lord. And the answer is no, it does not go against me. Rather, it strongly supports the position that the concept of jurisdictional immunities are separate from and anterior to any questions about the extension and operation of national court jurisdiction. So I accept that jurisdictional immunities, paragraph 82, is considering a different situation, the situation in Italy that I described. But what one draws from that is a thread of preoccupation from the International Court of Justice that jurisdictional immunities come first, they are separate as a matter of concept from jurisdiction, and it frankly does not matter if a treaty extends or creates or opens the operation of additional jurisdiction of a national court. What matters is whether or not there has been a jurisdictional immunity that is in existence, and in the circumstance of this case, the question is whether it has been waived. The status of these principles as general principles, which are not limited to a particular type of jurisdiction or a particular type of activity, were confirmed in the quote from Fox and Webb that I put on the screen, or you put on your screens, on Monday. If I can bring that up again, please. It's at page 351 of the first supplementary bundle, behind tab 19 for those who are somewhat old-fashioned. And it's in the bottom half of the page where the learned authors of this leading text are explicit that the emphasis is on express consent with regard to the matter or case. Waiver of immunity.
Sorry, you're on page 351, under the heading Interpretation of the Convention.
Scroll down bottom.
Supplemental bundle 1, my lord, is that what?
Yes, I've got the page, but I just can't find the passage on the page.
It's the final paragraph on the page, my lord.
Yep. Under Article
The quote from arrest warrant.
So the quote from the arrest warrant is part of that final paragraph, my
I see,
lady.
but you're going over onto
a bit just before it.
We will eventually go on to 352, but if I can start in the chapeau before the quote from arrest warrant. That's where the learned authors say, waiver of immunity and consent to the exercise of jurisdiction in respect of a state cannot be inferred by mere implication from a provision in which the state agrees to exercise jurisdiction over certain activities. My lord, Lloyd Jones,
I'm sorry, I've still not got the passage. The internal numbering, is it 295?
294, my lord.
294. So there's a quote from arrest warrant. Is it before or after that?
Before.
Immediately before.
Immediately before. Thank you.
I apologise, my lord, for not...
Not your fault at all.
I'll pause just to let you read it. Again, a recognition by the leading text of the general application of the principle from arrest warrant, which also has its echoes in jurisdictional immunities. No answer to this point by my learned friends yesterday or today. The same point, I will just recall for the court, was made by the International Law Commission in its quite recent commentary on its draft articles. I won't go to them again now, given the time, but the reference is supplementary bundle, page 387, and it was commentary, paragraph 8. In my respectful submission, the only way to distinguish arrest warrant and to cancel out the echoes of that general principle through the International Court of Justice jurisprudence is if the generality of that principle is somehow diluted. And we've discussed over the past 2 days various ways in which that dilution might occur, whether there is an extension of jurisdiction over only certain activities rather than events, or whether it is only with respect to certain types of immunity, like immunity ratione personae, or where perhaps the immunity and the jurisdiction conferred overlap or even might be coextensive. With respect, my lords, my lady, none of that is apposite. And I have 3 points on that. The first is that to dilute the principle in that way, or to seek carve-outs or exceptions, would not be a principled application of that statement at arrest warrant, paragraph 59, and echoed elsewhere. As I've said, jurisdictional immunities exist as a self-standing concept, not to be confused with where a treaty extends jurisdiction. And those immunities cannot be diluted by assumptions arising out of, or the desirability of exercising a jurisdiction conferred by a treaty or encouraged by a treaty that would otherwise operate in the absence of the immunity. One may wish for that jurisdiction to operate or be effective or have particular effects. Those who suffered at the hands of German troops when they brought their claims to Italian courts no doubt wanted the jurisdiction of Italian courts to operate, but it didn't. The application of this general principle is preliminary, absolute, and not to be conferred with the conferral, not to be confused with the conferral or exercise of jurisdiction. I have one further point on this before I move on. There has been some suggestion over the course of today and yesterday that the immunity that we are discussing in this case is not coextensive, is coextensive with the jurisdiction that Article 54 obliges states to create. With respect, it is plainly not coextensive. That jurisdiction extends not only to awards against states, in respect of which there is immunity, the matter before the court now, but it extends to a number of other aspects. It, of course, extends to awards against investors, in respect of which no immunity issue arises. We've quoted some of those in our written case. It also extends to state agencies nominated under Article 25.1 of the ICSID Convention. Could we please bring up the ICSID Convention? It's at the main bundle at page 2835. And I'm looking at Article 25.1, main bundle 2835. One can see there that the jurisdiction of the centre, ICSID, shall extend to any legal dispute arising directly out of an investment between a contracting state, brackets, and a national of another contracting state. Can we pause on those parentheses, please? It also extends to any constituent subdivision or agency of a contracting state designated to the centre by that state. So there are plenty of ICSID cases where an agency of a state is the respondent. It can also be a claimant, for which there are fewer but some examples. So in those circumstances, where there may well be no immunity for such an agency, whether under Section 13 or otherwise, and so they can be respondents to an ICSID arbitration, the overlap of the jurisdiction created by the Convention, including through the obligation of Article 54.1 in domestic courts, is not coextensive with the immunity that we have been discussing. Of course, my lords, my lady, you also have the point that the Convention also deals with other forms of jurisdiction as well, such as the compromissory clause for Article 64 to the International Court of Justice. That is not limited, as my learned friend Mr. Harris suggested, to when a state doesn't pay an award. Any dispute regarding the interpretation or application of the Convention can be sent to the ICJ under that provision. My lords, my lady, I only have a few minutes left, I think, before I hand over to Mr. Mulan. Can I please just deal with one point further, which arises out of the debate that's been had about express and implied? My learned friends have sought to say that there is a submission in Article 54.1, despite that not being stated in its terms. There's been a bit of a mix on the part of the respondents here. On the one hand, it's suggested that you can see that in its terms, but then my learned friend Mr. Green said, no, you don't need to worry about express or implied, you just need to ask if there's consent. Of course, there's no consent in the ICSID Convention. It's not created in order to formulate that consent. However, whichever formulation from the respondents one picks up, the point to recall in my respectful submission is that Lords Gough and Millett distinguish between an express submission to jurisdiction and an implied submission in the Pinochet judgment. If we can go to the Pinochet judgment, it's at page 801 of the main bundle. And can I just ask the court to read the paragraph from E onwards, beginning with I recognise.
Sorry, page?
801 in the main bundle.
And you want us to read from?
From E onwards, my lord. I recognise that a term onwards.
As far as letter H.
I'm grateful, my lord.
Later on. He seems to be saying that terms can be implied in treaties in certain circumstances.
My lord, can I make my submission by showing you just another reference before I then make my final submission, before I sit down, and I hope to address your question, my lord, then. So bearing in mind what Lord Gough says there, can I ask the court to bring up page 1080, 1080 in the joint bundle? This is a paragraph from the Bosnian genocide decision of the International Court of Justice.
Yes. We looked at this yesterday, 166.
We did, indeed. This was the main pillar of my learned friend Mr. Harris's case as to why a necessary implication can arise and be included as part of your analysis of Article 54.1. This was his flagship authority. If we read paragraph 166, though, it is quite clear that this paragraph is not saying that a necessary implication is part of the express terms of a treaty. Picking up at the second sentence, it must be observed at the outset that such an obligation, i.e. to stop genocide within your own jurisdiction, is not expressly imposed by the actual terms of the Convention. Moving down to the sentence beginning under on the right-hand side, about 10 lines down, court continues. Under Article 1, the states are bound to prevent such an act, which it describes as a crime under international law being committed. The article does not expressus verbis, require states to refrain from themselves committing genocide. However, in the view of the court, taking into account the established purpose of the Convention, the effect of Article 1 is to prohibit states from themselves committing genocide. Then the last sentence in the paragraph at the bottom, in short, the obligation to prevent genocide necessarily implies the prohibition of the commission of genocide. The point I want to take from these two authorities, my lords, my lady, is that the International Court of Justice is not saying that a necessary implication is part of the express term. It is a separate item. Indeed, consistent with this court's analysis in cases like Tesco, which I'm not applying English contract law, I'm simply identifying linguistic analysis that is relevant. An implication is separate from and subject to different rules compared to the identification of interpretation or identification of an express term. And applying what the International Court of Justice says, if one says that the effect, its word, of a provision is to be part of a treaty's meaning, then that is a necessary implication. And in those circumstances, where Lord Gough made the findings he did, and Bosnian genocide made the findings at paragraph 166 that it did, it is not enough to say, by way of necessary implication from the text of Article 54.1, the express terms contain a waiver to immunity. That is not enough as a matter of analysis of the text, because a necessary implication is separate from the express terms. And even if the court were minded to say a waiver of immunity is a necessary implication from Article 54.1, that leaves you only and squarely in the realm of an implied term. And of course, I do not need to reiterate to the court that all parties are agreed in these conjoined appeals that an implied waiver of immunity is not sufficient and does not satisfy the exception to immunity in Section 2 of the Act. My Lords, my Lady, I've impinged on Mr. Moulin's kindness, so unless there are any further questions, I'm grateful.
Thank you, Mr. Baston. Grateful. Mr. Moulin.
My Lords, my Lady, everyone agrees that a waiver of state immunity must be express. That requirement applies both under Section 2 and at the public international law level, and that is what happened in Pinochet, as the House of Lords had to apply Section 2 in a way that conformed with the position in the public international law. At the public international law level, under Article 31 of the Vienna Convention on the Law of Treaties, one does not begin by interpreting the clause and then perform a cross-check of whether the result one reaches is compatible with another rule of public international law under Article 31(3)(c). Article 31, which sets out the primary rule of interpretation, is a unitary exercise. There is no hierarchy within Article 31. Article 31(3) is mandatory. It says shall, and is co-equal with Articles 31(1) and 2. You must, therefore, interpret Article 54(1) having regard, as part of the task of interpretation, to the principle of public international law that a waiver of state immunity must be express. It cannot be implied. The usual test for implication, which Mr. Harris took you to, as in Serbian genocide, simply does not apply. Now, we do not say, and we have never said, and I don't know why the other side...
Why does it not? Why does it not apply?
Because it's
that might be considered to be a case in which a proposition of law was reached from two express statements.
Public international law, my Lord, does not forbid implications. Public international law forbids implied waivers of immunity. If you're using the test of implication to get a waiver of immunity, it's not express. That test in Serbian genocide is for general implications in treaties. If you accept that test as applying, then you might as well do away with the test that the waiver of immunity must be expressed. That is. But
it doesn't have to be. You can file a defence in the action.
Well, that is a specific, as Lord Gough explains, that is actually the one example that is given of something which is conduct, which...
Well, I can't understand why that's a special case, rather than an illustration of the general principle.
My Lord, then in that case, with all due respect, you're turning the principle on its head, and one might as well not say that you do not need an express implication.
If I think that may be the consequence.
You're right.
Yes, and as my learned friend Mr. Bastard is saying, it is a separate exception specifically identified in section 2.2 of the SIA, filing a submission. But one must give meaning, my lords, to what is meant by the waiver must be expressed. And if your conclusion ends up being saying, well, actually, is the same test as under all other principles of international law when you're going to imply a term, then you might as well not say that it needs to be expressed. And we do not say, my lords, my lady, that you need particular words, and we don't understand why the other side keeps coming back to that. You don't need, we accept the words waiver or submission or jurisdiction or immunity. The simple point we are making is that when you do not have those, you are not in a good territory to have a waiver of immunity. Why?
So let me be clear about this. You say that because there's a prohibition on implied waiver, that you cannot make a deduction from express provisions of the treaty which point to the necessity of immunity being waived.
I'm not saying that, my lord.
Which is the way it's put against you.
I'm not saying that. I'm saying that the normal test, which you see in Serbian genocide, is not the test. And I'm going now on to identify what the correct test is.
Well, that's a different point. But you are saying that the prohibition on implied waiver of immunity means that you cannot make a deduction from...
I'm not saying that.
...from express terms.
I'm not saying that. I'm saying
I'm not
that...
sure what you are saying.
My lord, let me explain then. What I am saying is that that test, the normal public international law test for implying a term, is not the correct test. If you allow me now to explain what I'm saying is the correct test. What you would normally expect, express means express. State immunity is an important principle. You would expect to find words of waiving immunity, of submitting to the jurisdiction. You're not finding them. I accept that you may infer them from the words that are there used. But when you're in that territory, care must be exercised to understand in what circumstances that inference would be permissible and in what circumstances that inference will not be permissible. And you need a test to do that. It's obviously not the test for implied terms. Otherwise, there would not be a prohibition on implied terms. That's why I'm using the neutral wording of inference. What is a permissible inference from the text? What is an impermissible inference from the text? And we know what the answer is because it's in Pinochet, my lords, my lady. That is what the House did. And what they said is it's not a simple test of necessity. It is a test of incompatibility. You have seen those paragraphs in Lama. You have seen what is said in Jones. You yourself, my lord, were saying as amicus in Pinochet, is it workable or is it not workable? That is the test we respectfully submit for when you may, by inference, find a waiver of immunity. And I think there is a danger of just assuming, oh, well, you know, surely one can just read that provision and seeing it, but then you are not applying public international law, which says that the waiver must be expressed. What does it mean? That you can just use the test for implied terms and deduct it? That you can just read it and say, oh, it seems clear enough to me? That you can go through a forest and get to a meaning? That's precisely why you have the requirements set time and again at public international level by the International Court of Justice that it has to be expressed. We've accepted it in this jurisdiction because it's obvious. And you can't just simply ignore it by saying, well, I'm going to apply just the general meaning of the words. No. If the words are there, the words are there. If they're not there, you're being asked to deduct it. You're being asked to make an inference. And you need to decide what inference is permissible and which isn't.
So I think I am right then in suggesting that you're saying that you cannot deduce, you cannot make a deduction from express terms.
Well, I'm not. If you take, let's take the Pinochet, and let's take the ratio which Lama gives for Pinochet. There was ultimately a deduction of a waiver. If we go with the Lama ratio, and I think I take Professor Webb's point, and I think let's go with the Lama ratio. What the ratio, therefore, of Pinochet is because the two were coextensive, the offense being created and the immunity, you could make the inference.
I think that's a separate point.
My Lord, with respect, I don't think it is, and let me explain. You're being told you have created jurisdiction. By creating that jurisdiction, it must follow that you have waived your immunity. That is an inference. If it was enough just to say that, you would not have those long speeches in Pinochet. But what you see in Pinochet is that the House is trying to understand, does it follow that by creating that jurisdiction to prosecute, you have waived the immunity? And the test that they go with, and it's very, very clear from Lama in these 6 paragraphs we read together, is absurdity, is incompatibility, is inconsistency, which makes absolute sense for 2 reasons. One, because obviously it's a higher threshold than the threshold for a normal implied term, and 2, because as I have explained, it tallies with the general principle, which I'm grateful to Mr. Green for correcting with respect, Mr. Harris, a rule of interpretation of public international law, which is effet utile. It's exactly that. If you're reading the provision, and the provision would be meaningless, would have no sense, unless you infer that waiver of immunity, then you infer it.
So you're saying that I think that the prohibition on implication does not prevent a deduction, provided there's total incompatibility.
My Lord, that's one way. Yes, I accept that. But it's very, very important with respect to see how one gets there. Right? You have a prohibition on implication. You then have circumstances where the words are not used. So normally you would not find a waiver. But you do go on and think, but could one be inferred? Is it permissible to infer one here? And there, and that's the beauty of it. You have Pinochet. And it tells you what the test is. And we do say that on the facts, Pinochet is ad idem with what we have here. Obligation to enforce, obligation to prosecute. And there was a submission, I'm sorry, I can't remember from whom, on the other side, that I think it was Professor Webb, that Article 7.1 of the CAT was somehow different because it said submit its case. Go through the whole speeches, you will not find that distinction. Submit its case is actually taking jurisdiction, and very much so, in the United Kingdom. So we say there is, in fact, no difference between the scheme of the 2 conventions. Now, that's on the facts of the 2 conventions. Now, Border also tries to say that in Pinochet, the immunity was in fact not coextensive with the offense because, you may remember, they were saying persons other than state officials might have been involved in official torture. And that is wrong. It is contradicted by all the speeches in Pinochet. And as noted by my Lord Lloyd Jones, such a person will be entitled to immunity as an agent of the state. And you can see that, in fact, from Jones at paragraph 10. And I'll just give you the reference. It's in the supplemental bundle at pages 43, 44. So you've got the same scheme, and you've got Pinochet clearly being a case of coextensiveness or unworkability or incompatibility. And they cannot escape from the fact, which is admitted by ISL, that Article 54.1 operates perfectly well without having to infer a waiver of state immunity. It is workable to use the terms of the submissions of the amicus in Pinochet, and indeed, it does exactly what it was designed to do. First, it fulfills its primary purpose, which was to provide a remedy for states against investors on the domestic plane where the said investors operate. It will always apply in that scenario, as that is a scenario where the state is submitting, it is suing. Secondly, it operates against the respondent state in its jurisdiction where it does not benefit from state immunity. Thirdly, it may operate in third states, and I'm grateful for the concession today by Mr. Harris, that in France that was already the case, depending on the domestic rules of state immunity in that third state. So it will depend.
These are the same 4 submissions that,
yes, they are.
That you made.
And I would add, so I'll move on from that.
And you also went on and made a 5th point, which was in relation to the presentation of an international claim. But you added to your...
Yes, exactly, my Lord. So that's on the...
We have it.
And I would now add what Mr. Bastien has said, which is also contract cases under ICSID, his last point. So we say with respect, there is therefore no waiver. And we refer to the travaux to confirm that meaning. So there's no question of a bullseye on either side. The travaux confirm our interpretation as they show that no one intended to harmonize the law of state immunity, including specifically immunity at the recognition and enforcement stage. And I showed you specific paragraphs where the only provision was one to enforce in exactly the terms of Article 54.1. And I showed you the exchanges with Mr. Burrows, the UK delegate, where he addressed the question of sovereign immunity in the context of a provision and a discussion on recognition and enforcement in the same breath as fraud. If, my lords, my lady, after that exchange, Mr. Burrows had been asked whether he had prospectively negotiated away the United Kingdom's immunity from adjudication in the courts of all future contracting states to the ICSID Convention following his return to Whitehall, his answer would have been, of course, not. And just one other point on the travel while I'm there, and I've got 3 points.
I think we're really at the very limits of time now.
Yes, my lord. Can I please ask for your indulgence? These are important points. I won't cover the points of the travel. I just wanted to say on Article 55, we do rely on the passage from Professor Schroyer that the respondents do not like, although they very much like Schroyer. And we say it is the only way of reading the text together. On pepper and heart, if I may, we say it is satisfied. The central question in this appeal is what the term submit in Section 2 means. The statutory provision does not specify whether it must be express or can be implied, and where one draws the line, and therefore is ambiguous in that respect. So that's what we say on pepper and heart. And the Court of Appeal, and that will be, my lord, I
think you used much of your time to reply in advance, so you're trying to take it back again now.
No, I know. I know, my lord. So I would just say that the Court of Appeal actually used Hansard to dismiss the possibility, which I believe my Lord Legate floated, that immunity from adjudication does not arise at all at the stage of enforcement. That was what Mrs. Justice Dias held at first instance. It was conceded by Border on appeal, and the Court of Appeal agreed. And that is at the Court of Appeal judgment paragraph 10 and 11, Zimbabwe call paragraphs 175, 176. And finally, we'll just ask you, please read Mr. Brock's article carefully, particularly the part on Article 55, where he explains that there could not have been any consensus on state immunity at that time.
Thank you, Mr. Lynn.
I'm so sorry. I'm grateful for the indulgence.
We're grateful to you. Thank you very much. In a pretty intensive 2 days of submissions, we've come to the conclusion of the first part of this appeal, completed the argument on the first part of the appeal. The court will now take stock of where we are in the light of the submissions that we've heard. The court is now adjourned. Thank you all very much.